When looking at the federal courts as policymakers, it's important to outline the judicial process at the Supreme Court level, as well as to look at the factors that influence the justice's decision and the implementation of their final decisions. The Supreme Court first has to decide what cases it wants to hear. They are in control of their own court calendar or their docket, so they get to decide what cases that they're going to review. About 8,000 cases are brought to them for review. Court cases that are brought to them on appeals, 99% of them are denied. It only takes the Supreme Court Chief Justice to say, these are the cases I want to hear, and those are placed on the docket. He also opens it up to the other 8 associate justices, and they can implement the rule of 4, which means if 4 out of the 9 justices say that they want to hear a case or review a case, it is then placed on the Supreme Court's docket. When justices have their docket set for the Supreme Court, they then issue what's called a writ of certiorari, which is a command to the lower courts to send up the documents, the records of the case, so that they can review them before examining the case. So as you can see in the diagram, the cases that start in the state court or the federal courts are then requested for the Supreme Court to review. The appeals are discussed. 99% of them are denied. If 4 justices vote to listen to a case, it's then placed on the court's docket. So they can listen to between 100 to 300 cases in a year. Other than the 9 Supreme Court justices, the next important person to know or figure that plays a role in the courts is the Solicitor General. They are the 3rd ranking official in the Department of Justice. They are a presidential appointee, and they are in charge of the appellate court litigation of the federal government. The second task of the weekly conferences that the Supreme Court justices engage in is to discuss the cases that have been accepted and are going to be argued before the court. Beginning the first Monday in October and lasting until June, the court hears oral arguments in 2-week cycles. Which brings us to step number 3 on this diagram. And unlike a trial court, justices are familiar with the case before they ever enter the courtroom, so the Supreme Court justices have questions prepared for the attorneys. The court will have these written briefs from each party. They may also have amicus curiae briefs that have been filed, which are documents from friends of the court that are interested in the case but have no part in the case. In most instances, the attorneys for each side have only 1/2 of an hour to present their arguments and address the court. After that, the justices may ask questions of the attorneys, but then they break and leave and head into a conference room where cases are discussed in absolute secrecy. The Chief Justice calls first on the Senior Associate Justice for the discussion, and then the rest of the justices in order of seniority. Once a tentative vote has been reached by the justices, then they draft their opinions. An opinion is a statement of legal reasoning behind the court's decision. A majority opinion means that 5 justices have decided one way or the other in a case. A dissenting opinion simply means a justice who disagrees or is opposed to the majority's decision. And the concurring opinion simply means the justices support the majority decision, but for different reasons, whether they be constitutional or legal. For the justices may spend months negotiating a majority opinion. It is typically the job of the Supreme Court Chief Justice, if he falls in line with the majority, to write that opinion, but those justices will discuss and debate how that needs to be written. That can be part of the most important part of the Supreme Court justices' decisions that they hand down, because those are the basis for future arguments. The vast majority of cases coming to the Supreme Court are based on or decided upon stare decisis. Simply means that the justices are referring to an earlier case to make their decision, and they rely on precedent, how similar cases have been decided upon in the past. Lower courts are expected to follow precedent. They don't typically set precedent. And then finally, you have to look at judicial implementation. So as soon as the court's decisions are handed down, those have to be turned into policy, and those have to be implemented by the federal government, the bureaucracy, and the executive branch itself.